and welcome to this week's edition of CGconnect, brought to you by Clifford Gouldson lawyers. This week I thought I'd talk with you a little bit about export advisory. Now, over the past decade or so, increasingly we've seen clients expose themselves to opportunities in overseas markets. Recently that has escalated because of the fantastic development that is the Wellcamp West Brisbane Airport. Obviously, as clients that manufacture goods or offer services into international markets, it's important that they think about how they want to expand their business across those markets. Quite commonly, we're asked for advice about how they structure that operation. Generally, it's important to separate the risk associated with venturing into an export market from your core domestic business. If you have the same trading entity that contracts for export opportunity as is trading domestically, you're exposing your domestic business to the risks associated with that international trade. For this reason, we recommend our clients consider creating a separate legal entity, whether that be a company, a trust, or another legal entity, such as a joint venture or a partnership. We recommend strongly that a separate legal entity be used for those export opportunities and any contracts associated with that. That new legal entity can contract with your domestic entity where required. Any finance that you might obtain, you may need to have an arrangement in place with your financier where your existing domestic entity guarantees or commits or promises to meet performance obligations of that export entity. But you want to cap those obligations as much as you can. When you're dealing with overseas corporations, there's a whole set of things that you need to look at and consider before diving in. You need to think about issues such as the sovereign risk of the country in which you're going to be trading. What are the laws of that country? Whether it be laws around tariffs or entries, barriers to entry, whether that be around employment law and obligations if you engage employees. You also need to think about taxation and what repercussions there are around goods and services type tax or value-added tax or income tax. Something else that we find is very important and crucial is that you need to make sure that you consider what structure you want on the ground in trying to sell product or sell services in those overseas jurisdictions. And there's no substitute for doing the groundwork to identify country by country what is likely to work best. When it comes to moving those goods, you need to think about logistics, cold chain or not. You need to think about terms. What terms are you going to impose or are going to be imposed on you when you start to sell goods or services into that jurisdiction? And in relation to goods, you need to think about Incoterms, international commercial terms. You need to be clear about the different Incoterms and which one will apply to the goods as you move those goods into that jurisdiction. If you need any advice in relation to export advisory, then feel free to reach out to Clifford Gouldson lawyers. Our export advisory team can certainly assist you. Until we speak again, all the best to you, your business and your family. Bye-bye.